Hi, it's Lori Brown with yournurseattorney.com, and we are here today on our 7-part video series on the 7 ways in which you can get called before the board. And today is day 5, and we are talking about lifting probation and suspension. Now, unfortunately, at least in Indiana, and I'm sure a couple other states, probation and suspension doesn't get lifted automatically. On your final order, it will say you are placed on indefinite probation or indefinite suspension, but may reapply to lift that suspension or probation after, say, 6 months, a year, or after a certain condition, like fulfilling your ISNAP or whatever peer assistance program monitoring that you may be in. So what you have to make sure that you meet all the conditions to lift your probation or your suspension. And I'm talking about every single one. I'm surprised the number of people that come to me and one of their requirements was to have their supervisor sign the final order and get it to the board within 10 days of the date of the order. And if you don't do that, then you're not in compliance. So there's ways to get around it if you're not in compliance. We can write a letter of explanation from your boss. There are things that we can do, but you have to be in compliance in order to have that lifted. When you actually go to a hearing on lifting your probation or your suspension, at least in Indiana, it's a real hearing, and it's set up like a courtroom. There's a plaintiff's table, a defense table, or a petitioner table, and a respondent's table. There's a board member, or maybe even the entire board. There is the board attorney, and there's a court reporter. And the court reporter is going to take down everything you say. And the way the hearing starts out is if you're the petitioner petitioning to get off probation or suspension, then you're the one who gives an opening argument. So you would present your case, just a summary of it, just overview of it, and what evidence you're going to show. And at the end of your opening argument, what you would like to happen. Like at the end of the evidence, I would like you to lift my probation, or whatever it is. And then you have to start calling your witnesses. You'd call them one by one, and the state has the opportunity to cross-examine your witnesses, and the board also has that opportunity to ask your witnesses questions. You'll also need to present evidence and put evidence into the record. That means you have to get any evidence marked by the court reporter as Exhibit A, Exhibit B, Exhibit C. You've seen that all on TV, I'm sure. And then ask that the board member admit that evidence and make sure the state has no objections. And then the state gets the opportunity to present their case, and they can call witnesses too. And don't be surprised if they have some blasts from your past come to testify against you. It can be, the state has to do their homework too, and they want to know that you're safe to practice. So they may surprise you with some things. They may surprise you with how many prescription drugs you've taken during the year. So it's important that you know what evidence the state is going to present and be prepared to handle that. You want to present your testimony in the light most favorable to you. And at the end of the evidence, you're going to have the opportunity to present your closing testimony or closing evidence. It's not testimony. And at the end of the evidence, you want the board to lift your probation or lift your suspension. It sounds a little complicated and it sounds a little law and order for nurses, but it's easy to get through the process. And if we can be of any help, please call the number below or send us an email. We'd love to hear from you. And stay tuned for day 6, which is about emergency suspensions. Bye for now.